content or assets that's made for our brand is automatically owned by us. That is absolutely not true, and I'm going to talk you through why that is. Hello and welcome to Engage and Thrive, also known as EAT, your coffee catch-up with me, your host, Taelon, where we will go through common problems and hurdles that come up in business, marketing and advertising and try and demystify them. I know firsthand how complicated and confusing it can seem with all the different acronyms and all the things to do in business. So let me try and help you be better in business. First things first, let's start with grabbing a coffee. So I'm going to be slightly dramatic on this topic, but I think it's necessary because I think far too many people just brush over the fact that if something has been created or you think you're creating it for your brand, that you own it. And that's absolutely not true. If you think of like social media and you think, oh, there's a trending song and I'll just add that, you don't necessarily own the rights to that song. And if you read about some of the platforms that actually own the rights to your content when you upload it, which is why over and over in all episodes, I keep talking about how you need to own spaces that aren't necessarily on social media. But even within that, if you're engaging with agencies or freelancers or influencers, there's so much that comes into it around who owns what. And it's so important to know the different types of ownership. So, as always, let's start off with vocab because this is really important. So the first one is IP, which is intellectual property. So a lot of people will talk around who owns the IP of an asset. And when you're doing contracts like between an agency and a client or a freelancer and a client, you'll have that as a clause around who owns what IP. Then thinking about copyright. So copyright can be for numerous things. Copyright can be for a song, a image, a scene that's being created, a book, a quote. People recently, was it Paris Hilton that owns the copyright now to It's Hot or something like that? There's so many things that have different copyrights around them, which then kind of leads into licensing and Creative Commons as a variation of licensing. So licensing talks about how and where you can use things. If you want to use stock videos, you need to look at the licensing of using those stock videos. So some things will say, yes, you can use it on social media, but no, you can't use it for advertising purposes. And even within that, it may say if you're using it for advertising purposes, it can only be online and it can't be for cinema and outdoor. The same with Creative Commons. So Creative Commons is a type of license that you can use, but you need to acknowledge who actually created it. So you may see on YouTube with people like commenting about who created a song, or if people using stock images or something and they may comment of who actually created it, even though it's a business. Then is trademark. So trademark is a very interesting one. You may or may not know, I've actually trademarked my name. So Taelon is trademarked. My name is actually made up by my parents, so it is unique. And no, they weren't hippies. But actually using Taelon as a business for a trademark, I had to pick the categories that I wanted to use Taelon in as a category of business. And then when you trademark, you can trademark a icon or a word mark. So Taelon as a name or Taelon as a logo icon. So there's different variations. And again, with trademarks, it depends on the country and fair usage around it, and you need to then renew it every however many years. In the UK, you renew every 10 years around a trademark. This also means then if someone uses your name or your logo or whatever you've trademarked, you can actually have a legal act or legal implications for their usage, or you could license it to them. Then if you think about UCG, so user generated content, UGC, sorry, I always get tongue twisted around that. User generated content, this kind of falls into influencers, and a lot of people think, oh, this is great, we've got influencers making content for us, or Facebook marketing creating content for us. Again, likely that there'll be licensing restrictions around it, and also to make sure that you know all those, because they could then be using it for other people. They've created that content, you think you own it, but actually you didn't sign any legal usage around it. Then there is patents. So patent is normally an idea. Dyson is the one that always comes to mind when I think of patents. They have patents around their technology. Apple, they have patents around like the AirPods and technology that they use. But it might be an engineering design, or it could be a concept. And the last one to think about is work for hire. So if you are an employee of a company, then you typically have it in your employment contract that anything you create while you're at that company is owned by the company. The same with, so to disclose, I actually did used to work at Dyson, and we had a clause in ours that says any ideas you submit while you work there are Dyson's ideas. So there's a few things that I know for a fact as well that I actually did submit in my time, not saying that anyone else didn't either, but it's interesting to see where the market has evolved based on what ideas we were submitting in the field. Okay, so as always, let's go through takeaways. So we've got 3 key takeaways today. The first one, number 1, is understanding the differences. So like I've obviously gone into quite in depth in the vocab, you really need to understand the differences between the different IPs, licenses, contracts, who, what, when, why, how. And if you don't understand the differences, get clued up. This is your sign to get clued up. There's no excuse to say, oh, well, I didn't know. Here's your sign. Understand the differences and get familiar with it. Because the worst thing is it'll come back and bite you on the arse. And it'll hurt because you've missed a clause or you didn't understand around usage. Like I was obviously alluding to with user-generated content, it's really important to understand if you have the rights to what they've created for you. The same with social consent. So if you're going to be posting people that have actually posed for your brand, having their social consent to actually post it on social media or a website, or even to use it in adverts. So people may say, yeah, you can post me on social, but no, I don't want to be in your ads. There's also rules in countries around consent for images. So for example, in a lot of Asian countries, you can't just do a photo shoot and have random people walking around and you're taking those photos and use it for advertising. You actually would then need consent from the public and those people if you use it in your advertising. So that's why if you were doing a full-blown ad campaign, it's better to just have no one that you don't know and only people that you do know with your actors. Number 2 leads in quite nicely is always check. So when I'm saying understanding it, and if you don't understand, always check it. So again, this kind of works into a lot to do with social media, with nowadays with trending songs and usage of content and stock images and videos and photos and everything. Check the rules around it. We all love Canva, right? And Canva is amazing for creating content and sharing templates and using other people's templates to then create your own designs. Again, understanding what the usage is on that and how much you've actually changed the design to make it yours and therefore what you can claim as yours. The other one is around AI. So there's loads of things changing around the usage of AI. Up until probably a couple of weeks ago, if you created any content around AI, it was kind of yours, who kind of said who owned it. Now there's actually policies in place and there's more rules changing, especially in the EU, around how you created it, what's the risk of the different levels of the AI creation, and therefore who owns what, and what can actually be used in a court of law as you've created content as your brand to own. And the final one, which is the most important one, which is number 3, is having legal contracts. So legal advice, legal contracts, having someone you can contact, understanding the different websites to check legal rules around usage, IP. There's an actual, so in the UK, as I mentioned before, there is a trademark checker for intellectual property. There are patent websites to check around patents. So if you have a startup and you think you've got this amazing idea and no one's ever come up with it, check a patent on it, especially if it's a product. The same with if you have people to come into your business, like freelancers, agencies, whatever, understanding every little terms of those contracts around who owns what, and especially as a afterthought. So can you use that? If, for example, you have a workshop and someone attends, so I run workshops, and then after that, if I'm teaching anything as an intellectual property, is it my intellectual property, or have I handed that IP over to a client, and therefore they are allowed to run it internally with teams? These are all things to check. So legal contracts is really important. But all in all, as a total takeaway, it's an interesting topic, but the main thing is get familiar, get knowledgeable, and understand the different implications, because you probably don't own what you think you own. But thank you for joining me for another episode of Engage and Thrive, and see you next week.